I'm Sarah Nicola. I'm a new faculty member in the Department of Indigenous Studies. So I have the great pleasure of introducing our February 2016 installment of the Indigenous Studies Speaker Series. And this month we're doing this in collaboration with the Native Law Center. So thank you very much for inviting us to this beautiful space and hosting us here. So our speaker today is Professor Karen Drake from Lakehead University, who will be speaking on law and the politics of the Métis title. So I'll just give a little bit of a brief background on Professor Drake, who she is before. So Karen Drake is a citizen of the Métis Nation of Ontario and currently serves as chair of the Thunder Bay Métis Council. She is co-editor-in-chief of the Lakehead Law Journal and was previously co-editor-in-chief of the Indigenous Law Journal. She is also a member at large on the Indigenous Bar Association's board of directors. Prior to joining Lakehead University, she's done a lot of stuff. Professor Drake practiced with Erickson and Partners in the area of civil litigation, focusing on Aboriginal legal issues, human rights, and labor and employment law. Prior to that, she earned public castles, Broad and Blackwell LLP. She completed a clerkship with the Ontario Court of Appeal, where she clerked with Justice Stephen Orens, Justice Susan Lang, Justice Harry Reform, and Justice Gloria Epstein. Like I said, she's done a lot of stuff. Currently, Professor Drake teaches Aboriginal law, Indigenous legal traditions, and political law. Her current research interests include the intersection between liberalism and Aboriginal rights, the duty to consult and accommodate Aboriginal peoples in the context of resource extraction, and Métis legal issues. So we very much look forward to hearing you speak. Please join me in welcoming Professor Karen Drake. Thank you.
Ani, bonjour, Hache. I want to acknowledge that all of the traditional territory of the trees, 6 First Nations, and the traditional land of the Métis. I want to begin by thanking the Department of Indigenous Studies and the Native Law Center for hosting me. I also want to start with a little apology about my voice. So you'll hold, hopefully the sound is raspy, and see how long it comes out. So this paper that I'm going to be talking about today is one that I've actually co-written with Adam Godry from the Department of Indigenous Studies. So when I told Adam that I'd be here, I suggested we present a paper together. He said, yeah, that's great. So it's all, he set it up. How's that? Okay. So yeah, that's great. He set it up. We're going to present this paper. And then a week or so later, he contacts me and says, oh, wait, actually, I forgot. I'm already committed to present a paper in Halifax at Dallas at the same time. So it's just me. So the title is The Law and Politics of Métis title. In terms of that title, I'm the law, I'm going to politics, so you're actually only going to get the law in this talk. And so I was also responsible for the history aspect as well. I'm going to do my best to convey this aspect of it, but if you quote me on the history part, I think you're going to find my answers are not very satisfactory, so I'll just let you know why I have time as well. Okay, so when it comes to Aboriginal rights and title analysis, the Métis are usually about 15 years behind First Nations when it comes to establishing a jurisprudence. And so we want to know what's going to be on the horizon for the Métis. We can look to see, well, what just happened with respect to First Nations, and that's probably what we see coming up. And so what we've seen most recently, of course, was the Tsilhqot'in decision, where for the very first time, Supreme Court of Canada granted that declaration that Aboriginal title actually exists, right? The First Nations actually able to establish Aboriginal title. So that leads us to the question: does that mean that the next big issue on the horizon for the Métis might be Aboriginal title? Now, some scholars have put forward arguments that the Métis are not only able to establish Aboriginal title. And I characterize these arguments in 2 ways. There's sort of these 2 sets of arguments. One set is that the Métis are too mobile to be able to establish Aboriginal title. And the other argument is that the Métis are too immobile to be able to establish Aboriginal title. So I'm going to argue against both of these positions. Okay, so Aboriginal title. What does a nation have to prove? Well, there are 3 things. In order to establish Aboriginal title, the claimant nation has to show that their occupation of the territory at the is first sufficient. Next, they have to establish continuity of occupation. And then finally, they have to establish exclusivity of occupation. So for the sake of time in this presentation, I'm going to focus on the first one, so sufficiency of occupation. So this notion that the Métis were too mobile to establish Aboriginal title really goes towards the sufficiency requirement. It says that the Métis can't establish sufficiency of occupation because they're too transitive. It's based on this myth of Métis transience, that they're a society perpetually in motion, chasing the buffalo, transporting goods, hunting birds. So Tom Flanagan is a proponent of this notion of the Métis are too mobile. He argues that the Métis didn't hunt and gather in any specific territory. Right? They're just roaming at random, roaming the plains at random. They just went wherever the buffalo went. Right? If the buffalo can't establish Aboriginal title, the Métis can't either. Right? They're just doing with buffalo. They're just wandering aimlessly and roaming around the plains. Okay, so let's assess this notion that Tom Flanagan puts forward. Is this actually correct? Well, what are the requirements for sufficiency of occupation? It turns out there's two different components to this. One is that the Aboriginal population has to use the land at a certain level of intensity and frequency. And the other aspect of it is the relevant date, right? What's the assessment date for, what's the date we need to look towards when assessing whether the occupation was sufficiently intense and frequent? So first we need to start with the date. Now, the date that the Supreme Court of Canada has consistently referred to is the date of the assertion of common sovereignty. So that's the phrase that the court uses over and over again, assertion of common sovereignty. And when we look at the actual cases, that's also what we're doing. We're just looking at the mere time at which the court asserted sovereignty. So, for instance, in Delaware, the date was 1846. So that's the day of the Oregon Boundary Treaty. That's when British establishes the boundary between British North America and that area vis-a-vis the United States. Then in Marshall decision, we have 1713, which is the Treaty of Utrecht. So that applies to mainland Nova Scotia. Also in Marshall, with respect to Cape Breton, the date is 1763, and that comes from the Treaty of Paris. Right? So again, the date is vis-a-vis Britain and other European nations. And in Bernard, the date is 1759, and it refers to Britain's conquest of France's territories in that area. So again, the date is just with reference to Britain's assertion of sovereignty vis-a-vis other European states, but not with respect to indigenous nations. Okay, so this it could be an issue for the Métis, right? If Aboriginal title is to be assessed as of the date of the assertion of sovereignty, then the prospects don't look that good for the Métis. And the reason is because it's arguable that throughout Rupert's land, the date of the assertion of sovereignty is 1760, which is when Britain issued the charter, since Great Company granted an monopoly over Rupert's land. Right? That's 1670. And it's widely acknowledged that the epigenesis, the emergence of the nation happened much later than that, in the late 1700s. So if that's the date, that's going to be an issue. Now, other scholars will have persuasively argued that that should not be the appropriate date, right? That's not the date that should be applicable either for the Métis or for any other indigenous nations with respect to either title or Aboriginal rights. So other scholars will argue that a more persuasive date would be effective control, right? So at the time, I wish that one established effective control over the territory. So I'm not going to repeat all of those arguments here, but what I do want to do is point out that there's an additional argument in support of effective control as the relevant date that comes from the Tsilhqot'in decision. So specifically, paragraph 69, a unanimous Supreme Court of Canada in Tsilhqot'in boldly proclaims that, quote, the doctrine of terra nullius, that no one owns the land prior to European social sovereignty, never applied in Canada. You know, wow, that's great. You know, from an indigenous perspective, reading that, you think, oh my goodness, I didn't realize that the doctrine of terra nullius never applied here. I'm so glad the Supreme Court just asserted that everything's fine now. No terra nullius, no doctrine of discovery. So unfortunately, of course, it doesn't work that way, right? Merely saying it doesn't make it so. In fact, the reverse is true, right? The doctrine of terra nullius is still very much operating in the Tsilhqot'in decision. So the entire analysis in Tsilhqot'in is still premised on the assumption of the doctrine of terra nullius. Right, so the Aboriginal title analysis says that the mere assertion of sovereignty is the assessment date for Aboriginal title, because that's when the Crown acquired underlying title to the land. And Aboriginal title crystallized at that point. It crystallized at the point where the Crown acquired underlying title, and it became a burden on the Crown's underlying title. And so the fact that the court is still using the mere assertion of sovereignty as the assessment rate shows that the doctrine of nullius is still operating, right? The mere assertion of sovereignty, regardless of the existence of indigenous peoples in the territory, is still what is operative in the reasoning. But of course, there is a way to make the court's bold announcement actually true, right? And the way to do that then is to abandon this notion that the mere assertion of sovereignty is what gives the underlying title and is the relevant date for assessing Aboriginal title. So instead, we can recognize that what the Crown has is merely de facto sovereignty. And this is a point that Tom has made very well, very persuasively, and Brian Slattery as well. So if what the Crown has is de facto sovereignty over Aboriginal title lands, in other words, effective control, then the relevant date would be the date when that de facto sovereignty occurred, right? The date when applied effective control. Okay, so that's one more argument to add, like I said, to the course of other arguments as to why you should reject this notion that a mere assertion of sovereignty should be the relevant date. Okay, so next let's talk about the actual standard for assessing the sufficiency of occupation. So prior to the Supreme Court of Canada's decision in Tsilhqot'in, it started to look like the standard was going to be really high. It seemed like it was going to be next to impossible, if not impossible, for nomadic or semi-nomadic nations to ever be able to establish sufficiency of occupation. And for instance, we have the BC Court of Appeal decision in the Tsilhqot'in case, and in an article written before the Supreme Court of Canada's decision in Tsilhqot'in, Kent McNeil analyzes the BC Court of Appeal and shows that the standard that they applied in Tsilhqot'in is actually higher than the standard for adverse possession. Right? They were holding the Tsilhqot'in issue to a standard even higher than adverse possession. So, the jurisprudence just sort of started like building up and building up. The standard that Aboriginal nations have to meet just seemed to be so high. You have to do even more than what an adverse possessor has to do in order to get your Aboriginal title. However, we finally get clarification in the Tsilhqot'in decision, which says that no, adverse possession is not the standard for establishing Aboriginal title, and certainly not anything higher than adverse possession. Instead, the standard that Aboriginal nations have to meet is what's called the standard of general occupancy. Right? So they have to meet the standard of a general occupant. And this standard is lower than the standard for adverse possession. So at common law, a general occupant is not trying to oust the original owner the way an adverse possessor is. Right? So a general occupant is someone who is asserting possession over land that no one else has a present interest in, or with respect to which title is uncertain. Right? So it's a different scenario from adverse possession. I'm not trying to oust anyone. And in his article, Kent recognizes that this rationale makes sense in the Aboriginal title context because Aboriginal peoples are not trying to oust anyone either. Right? So, Métis says, quote, Aboriginal peoples in the Aboriginal title are obviously not wrongdoers. On the contrary, they're claiming Aboriginal title because they were in rightful occupation of their traditional lands at the time of assertion of sovereignty. Right? So that's a relevant period. So, in other words, the Aboriginal claimants are the original occupants. Right? That's why they should be in the position of the general occupant. That's why the general occupant standard applies here. Okay, so if that's the standard, though, that might raise some questions when it comes to the Métis, right? So I can just foresee some scholars arguing, oh wait, yes, but the Métis were the original occupants, right? Logically, by definition, the Métis would have been the original occupants of the land, because by definition, the Métis arose later, right? Europeans had to be here first before the Métis could have arisen. And so therefore, they're not really the original occupants, they're not really claiming land that no one else has an interest in. And so it's not actually the general occupants land that should apply to them. Maybe we should apply the adverse possession standard to them. So this argument, though, I contend is persuasive, and it's based on a misconception, right? It's based on a misunderstanding the notion that the assessment date would be as of the arrival of Europeans. But as we just discussed, the relevant assessment date should be the date of effective control, right? The date of de facto sovereignty. And if that's the case, then absolutely there were Métis nations occupying their territory, occupying their land in an organized way, exercising jurisdiction, so establishing their own laws and making governments, and enforcing those laws in territory before there was any found effective control over that same territory. Okay, so those preliminary objections aside, let's talk about the standard for general occupancy. What does a general occupant have to do in order to establish title? Well, the Supreme Court explains in Tsilhqot'in that a general occupant has to show that it acted in a way that would communicate to third parties that held the land for its own purposes. Okay, so that's the standard. Now, that being said, the court goes on to clarify that the standard is contextual, and that means at least two things. So the first is that both the common law and the Aboriginal perspective are relevant in assessing whether the standard has been met. And the second point is that the standard is contextual in the sense that it's going to vary depending on the character of the Aboriginal nation and depending on the character of the land. Right? So we have to look at what kind of land is it, what is the land good for being used for, and how does the culture, the customs and the laws of the Aboriginal people say the land should be used, and did they use the land in that way? Right? So it's contextual. Depending on the land, depending on the character of the Aboriginal nation itself, and that's assessed with respect to the customs and laws of the Aboriginal nation. Okay, so that brings us to the question, and that means that what we're trying to determine is whether the Métis nation, prior to effective control, ever acted in such a way that communicated with third parties that it intended to hold the land for itself by using the land in a way that was capable of being used, given the characteristics of the land and given the Métis nation's own laws and customs. Okay, so to answer this question, first what we need to do is recognize that this myth of Métis transience that I mentioned is just that. It's a myth. So Brenda McGoogle in particular has demonstrated that the Métis were not just aimless nomads wandering wherever the buffalo happened to wander, untethered to any particular territory. So we rely on her work in order to show that the Métis traveled within a well-defined and that McDougall puts it, a regionally bounded geography that the Métis identified as their homeland. So far from having no specific territory that they define as their home, it's finding things. McDougall demonstrates that the Métis actually travel between very specific points of destination and points of origin. So, for example, Red River, by First Plains, Cypress Hills, Wood Mountain, San Juan, and So, in this paper, we submitted that the Métis buffalo hunt satisfies the contextual analysis that's required to establish sufficient occupation. Insofar as when the Métis are engaging in the Métis buffalo hunt, they're using the land in a way that's suitable to be used in accordance with their own laws and what their laws say how the land should be used. So one way to see this is to understand that in the prairies in the Northwest, buffalo hunting prior to effective land control actually a more secure occupation than farming. So the Red River experienced numerous agricultural failures in the early years. So for instance, the Red River often flooded, and there are also other serious challenges to agriculture. So for instance, several grasshopper infestations, which consumed mostly Solomons crops. So using land in an agricultural way was not necessarily the best use of the land. From the Métis perspective, according to their laws, the buffalo hunt was the most effective use of the land. Now, the buffalo hunt also involved Métis governments, involved Métis laws. It reflected the Métis political system. And Louis Riel in his writings actually connects the Métis buffalo hunt governance with Métis ownership of the territory over which the buffalo hunt proceeded. So, according to Riel, he argued that the Métis effectively governed much of the fur trade communities throughout the region, and that the Hudson's Bay Company was actually surrounded by Métis government, and that company men in the camps, in the winter quarters, and the Métis settlements were actually under the protection of Métis laws. And one of the clearest examples of this is the Métis refusal to comply with the Hudson Bay Company monopoly over trading, which happened in 1849. So prior to that, 1845, first the Métis refused to pay the Hudson's Bay Company import duties. Then in 1849, we have the Métis declaring the death of the company's monopoly over trading and simply refusing to follow the company's rules in that regard, and instead implementing their own rules with respect to free trade. So by implementing their own laws, following their own laws for the territory, instead of the Hudson's Bay Company laws, the Métis are demonstrating this intention to use the land in a way that it's good to be used, it's good to be used for buffalo hunting, in accordance with their own laws, following their own laws, of course, along with First Nations laws as well. Okay, so that's my response to the argument that the Métis are too mobile. Next would come the argument that the Métis are too immobile to establish Aboriginal title. So this notion comes from the depiction of the Métis living in settlements like the Red River, where they live in these long lots that are lined up along the river base. And so the lots are 2 miles long and attached to the river base. And this argument finds its basis in Supreme Court's decision in Manitoba Métis Federation, which was released in 2013. So this case was about Section 31 of the Manitoba Act of 1870. So in 1870, the Métis of Red River agreed to extinguish their Indian territorial lands in exchange for 1.4 million acres of land. And then this agreement was enshrined in Section 31 of the Manitoba Act, which then gets constitutional status. But the problem was that the Métis, for the most part, didn't get their 1.4 million acres, and so they eventually bring action that results in the Manitoba Métis Federation decision. So in that case, ultimately, Jurisprudence of Canada held that Canada breached its duty to uphold the honor of the crown because of its negligence in actually delaying its duty of 1.4 million acres of land. However, the Manitoba Métis Federation also made another argument in this case, and that's the one I want to focus on here. So what they were arguing was that the Crown owed the Métis a fiduciary duty in giving them the 1.4 million acres, right? So in setting up the system that would distribute the 1.4 million acres of land to them. And they argued that Canada breached that duty.
So can you speak about the community movement back here and have that
I can't really because I have this.
Put the mic closer.
Is this how? Is it on? I know it's working before.
Yeah, it's working.
Oh, was it on?
Apparently, there's supposedly a volume button down there.
How's that?
There.
Oh, yeah. Yeah.
Yes, okay. Thank you, that's much better, thank you for pointing that out. Okay, so the fiduciary duty argument, ultimately the Métis lost that argument. However, there's a really interesting analysis that comes out of that. And so let's look at what was going on. So in order for there to be a fiduciary duty, the Métis have to establish two things. First, that they have a specific Aboriginal interest in the land at issue. And second, that the Crown undertook to exercise discretionary control over that interest. Now, it's only the first of these that are relevant to this analysis. So, a majority of the Supreme Court of Canada held that the Métis failed to meet this first requirement, right? They failed to show that they had a specific Aboriginal interest in the land. And the reason was because the majority said that in order to establish that they had this specific Aboriginal interest in the land, they had to show that they had a communal or collective interest. Right? The interest they have to have has to be communal or collective. And the majority said that the Métis and Red River couldn't do that. They couldn't show that they had a communal or collective interest. And the reason is because the court pointed towards these two key features of Métis landholding in the Red River, which the court says are akin to holding land as fee simple. Right? So specifically, the Métis in the Red River lived on individual plots of land. Right, the individual plots of land that I talked about along the riverways. So they're actual specific plots of land where they farmed, built their homes, and so on. The court also points out that the Métis had this practice of actually selling those plots of land. Right, so for the Métis, those plots were alienable. They transferred them. So since the Métis held these plots of land along the riverways as individuals, the court says that's not a communal interest. You're holding the plots as individuals, you're selling them, that's just not a communal interest. Now, although these arguments were made in the context of the fiduciary duty analysis, the court does actually go on to say, specifically at paragraph 59 of Manitoba Métis Federation decision, that what this means, this fact that the Métis did not have a communal interest in the land of the Red River, is that they also did not have Aboriginal title to that land. So, in other words, the Métis could not establish Aboriginal title to the land, to their land holding in the Red River, because they held the land in a manner that's analogous to holding land in fee simple. So, in other words, the Métis are too immobile to establish Aboriginal title. So, my response to this argument is that this just isn't the test for Aboriginal title. Right? This actually has nothing to do with the test for Aboriginal title. So, as we just discussed, there are three requirements for Aboriginal title: sufficiency, continuity, and exclusivity of occupation. This test makes no mention whatsoever of also having to engage in a communal pattern of landholding. Right? That's never been part of the test. If that ever was part of the test, then surely the court would have mentioned it, especially in Tsilhqot'in, which is the court's most recent, its final pronouncement on Aboriginal title, and which came out a year after the Manitoba Métis Federation decision. Now, that being said, yes, it is true that according to the jurisprudence, Aboriginal title is defined as involving a collective interest. Right? That is correct. However, it's important to note that this is the content of Aboriginal title. The collective interest is the content. It's what the Aboriginal nation gets when they're successful, when they establish Aboriginal title. It's not part of the test. It's not one of the hurdles they have to meet ahead of time in order to succeed. So what successful Aboriginal claimants get is a collective interest, but proving that they historically engaged in a pattern of communal landholding is not part of the title. And there's a good reason for that. And in order to understand this rationale, it's necessary to make the distinction between rights on the one hand and jurisprudence, jurisdiction on the other. So in our Aboriginal rights discourse, in the jurisprudence, we're used to talking about Aboriginal rights. Section 35 talks about the rights of Aboriginal peoples of Canada. the UN Declaration on the Rights of Indigenous Peoples is full of discussion on Indigenous rights, right? All we hear about is rights, rights, rights. And so that's what we end up talking about. However, the term rights in this context is a misnomer. Aboriginal peoples are peoples. Peoples or nations do not have rights. They exercise jurisdiction. Individuals exercise rights. So insofar as Aboriginal nations are entitled to apply their laws to their territory, what they're doing is exercising jurisdiction. So the terms used in Section 35 and in UN Declaration would have been more accurate if they had used the term jurisdiction. So the confusion in the Manitoba Métis Federation case results from talking about jurisdiction as a collective right, and then simply talking about it also results from this equivocation between the collective interest and a communal landholding pattern. Right? There's no necessary connection between having a collective interest, a collective right, or in other words, jurisdiction, exercising jurisdiction, and exercising it in a communal way. Right? But if you're only going to talk about a collective right, then it starts to get easier to slide between the notion of a collective right and a communal landholding interest, collective, communal. But when we realize that we're talking about its jurisdiction, then it's easier to see that an Aboriginal nation can exercise its jurisdiction in whatever manner it chooses. Of course, subject to the limitation in the jurisprudence that the land can't be used in a way that would substantially deprive future generations of their beneficial interest in the land. But leaving that aside, the Aboriginal nation can exercise its jurisdiction either by implementing laws that allow for communal landholding, if that's what it chooses, or by implementing laws that allow for individual landholding. Right? In the same way that the Crown exercises its jurisdiction to allow for individual landholding here in Canada. Right? So when the Crown does that, when we are entitled to hold our land in fee simple as individuals, the Crown doesn't somehow no longer have any interest in the land. Right? The Crown still has jurisdiction. It still has underlying title to that land. Okay, so not only is this not the test for Aboriginal title, but if this were the test for Aboriginal title, it would result in a vicious circle. So on the one hand, we learned from the jurisprudence from Dalton, Marshall, Bernard, and Tsilhqot'in that to establish Aboriginal title, what the Aboriginal nation has to show is that they occupy the land in a way that is comparable to what is necessary to establish title at common law. Right? And the standard is that of a general occupant, and there's a whole jurisprudence that exists at common law to say what a general occupant has to do to establish title. Now, granted, the Supreme Court of Canada does talk about balancing the Aboriginal perspective with the common law perspective. But in that balancing, the role of the Aboriginal perspective is just to give the interpretation a culturally sensitive lens, right? It's just to use a culturally sensitive lens when we're looking at this interpretation. The reality is the standard that is going to be used is the common law standard. That is what the occupation is getting measured against, right? The standard of a general occupant. So when Aboriginal nations fail to establish Aboriginal title, as they did in Marshall and Bernard, for example, it's because their manner of occupying the land is not sufficient to meet the common law standard. On the other hand, though, what Manitoba Métis Federation says is that if the occupation exhibited by the Métis Nation in this case is too close to the common law standard, then they also fail. Right? So in other words, if an Aboriginal nation occupies land in a way that's too similar to the common law, then they lose. If it looks too much like fee simple, they don't get Aboriginal title. So we have to comply with the common law to win, but if we comply with the common law too much, we lose. Right? This can't be the test that the Métis have to meet to establish Aboriginal title, because if it is, it's Kafkaesque. The goal of Section 35, as the Supreme Court has said over and over again, is reconciliation. If the test that the Métis have to meet to establish Aboriginal title embodies a kind of Kafkaesque vicious circle, that's not going to promote reconciliation. Thank you, Miigwech, Asay.
So I think we have time for some questions, so I'll just open the floor here.
I'll make a forward question. Okay. So the Métis want to get into the whole claims, land claim, and self-specificity, right? To me, it looks like you have a couple arguments that you can throw up to the federal government. One, Aboriginal title. You've argued this, you know, that Aboriginal title for the Métis exists, but also the idea of in the Manitoba Act that you haven't fulfilled your obligations pursuant to the Manitoba Act. So, irregardless of which branch you go down, it seems that you have essentially a land. So, in your opinion, why is the federal government not picking that up?
Okay, so if I could read the federal government slides. Yeah, politics and money. There isn't always a neat logical correlation between what, at least I interpret the law as requiring and what the government necessarily does.
Do you see them actually going down that avenue at some point to actually negotiate with Métis?
Well, I mean, I certainly hope there will be a resolution from that Métis Federation case, right? So the Métis did a declaration in their favor in that case, but no substantive remedy. They didn't ask for a substantive remedy. However, the point of asking for the declaration that the Crown breached the duty of the honor of the Crown is to use it in negotiations. And so I certainly hope that will be effective for them.
Thank you very much. There's some gaps in my understanding. I have a very simplistic question which comes from my simplistic understanding of this area. But I know it's also an open simplification to say that we should not have an Aboriginal title claim by a First Nation if there's a treaty that deals with land. Usually, those claims arising where there is no treaty that deals with land. So when it comes to Métis, is the Manitoba Act not really equivalent to a treaty in the sense that it's an agreement with the government which sets up terms? And if it is, and maybe it isn't, if it is similar to a treaty, then does it not include the whole reason we need to have this?
Yeah, and my partner Adam Gotri argues that the Manitoba Act is equivalent to a treaty. Of course, the Manitoba Act though only covers the postage stamp version of Manitoba, right? So just if I had a map, it's just this little teeny tiny corner of Manitoba, like right in the very, very bottom. And so that leaves the whole rest of Manitoba and the rest of the former Yukon, right? The rest of the prairies, the rest of the Northwest, as not having been surrendered in Section 39 of the Manitoba Act. And so, yeah, insofar as that's a treaty, then I can't speak for the Métis signatories of that, under Section 31, but presumably what they're arguing for is implementation of what they negotiated there as opposed to Aboriginal title.
It seems like in the hunting cases with Métis that they're focusing on not being mobile enough because they're restricted it to certain areas. But yet, if you look back at the history of certain communities, they moved the people there and said, you settle here. Well, although they might have occupied that area before. So it seems that that's where that notion is being implemented in hunting cases. Whether or not that's going to have the same impact of argument on being as Aboriginal type. But that seems to be what I'm seeing. Because those arguments, it'd be interesting how the Metal case on the hunting fishing goes.
Okay, great. Yeah, I'm not remember that.
Yeah, because it seems to be where it's going. But I find it interesting that mobility, immobility, how to reconcile the two, because if I look at the history of Manitoba and the movement of people, I mean, the movement of people occurred because of certain little things, not because some instances not because they wanted to, they were dispersed. And then other negotiations took place. So
Right, yeah.
something that's going to be unfolded as to what research is going to be done, and we said who's going to be doing the research in terms of history.
Yeah, no, good comment. So, sorry, I was just thinking of, just to follow up on Brooks's question. So, in terms of the Red River, yes, it's covered by Section 31 of the Environmental Act, but there are other Métis communities where they occupy lands in a similar way to that. Where they develop, right? So, in the long river lots of ways. So, those communities were sort of interspersed throughout the Google South River Plains.
I wonder if your distinction between rights and jurisdiction will come back to haunt you, because of course jurisdictions can be changed. Canadian government can change jurisdictions, I assume. I know my government changes jurisdictions of places all the time. And if rights are secured on the basis of we have jurisdiction over a certain area, if the jurisdiction changes, if people move, as the last question pointed out, whether they move because they choose to move or they have to move, then they no longer have jurisdiction. Whereas rights is something that follows wherever you go. And of course, in the international context, there are lots of people who claim rights when they have no jurisdictions. And so I'm just wondering if you want to think through a little stronger and harder, trying to, I mean, it's a nice point, but I'm wondering if it's going to turn around and bite you in a place where you don't want to be hit in the end, because what we know about legal history is you make a nice point and turn around and it comes after you.
Yeah, so that comment actually illustrates my point, the significance of my point even further. So yes, in the human rights context, rights do travel with the individual. But in the Aboriginal rights context, for most Aboriginal rights, and for certain ones, they are tethered to land. Right? Aboriginal rights are tethered to land, they're site-specific. You get the right to do the thing on the piece of land where you did it at the relevant time, right, as of the assessment date. So it might be that further illustrates the notion that we should be thinking about this as jurisdiction, not as rights. We're not talking about rights of individuals, we're talking about Aboriginal rights. We're talking about Aboriginal peoples exercising their jurisdiction, controlling how they live, controlling how the land is used, and wanting to continue to do that now.
I'm just thinking about the implications of this, and I guess I'm having a sort of a hard time visualizing. When you talk about the rights were mobile, and when you teach all about that, you mentioned site-specific. I'm just wondering what extent such claims would conflict with pre-existing claims to title by First Nations that were ceded through treaties.
Yeah.
I mean, you have these maybe overlapping.
So that's the whole exclusivity component that I didn't get into for the sake of time. But there's the third requirement in order to establish Aboriginal title, which is your occupational land must be exclusive. And so there's scholars arguing, okay, well, the Métis can't establish Aboriginal title. They never had exclusive occupation because the First Nations, they had title. And of course, yes, the First Nations do have title to most likely most of the land of the Aboriginal, or sort of the Métis would claim title to as well, except maybe the southern areas where they're occupying the river lots. However, Galgama very specifically says that, and when we're talking about exclusivity, we also will accept this notion of joint title. Right? There can be joint title, which means that the two Aboriginal nations, whoever they are, occupy the land exclusively, or to the exclusion of everyone else, other than themselves, the two of them. Right? So in our paper, we argue that for the most part, the Métis, other than in their settlement areas, would be claiming joint title with the other First Nations who are in that territory. And we rely on the work of Rob Innes from the Department of Justice here at the University of Saskatchewan. So in his book, he illustrates that the Métis in Saskatchewan in particular essentially shared land with the Cree, Assiniboine, and Saulteaux. Right? So that those four nations, Métis, Cree, Assiniboine, and Saulteaux, have this history of this really fluid kinship relationship and occupying territory together, the four of them. And we would argue that the four of them would probably assert joint title. Well, if there are no other questions, then thank you very much